judgment in the application of Haralambous versus Crown Court at St Albans and another.
Without statutory authorisation, the courts cannot, as a general rule, conduct closed material proceedings, that is, proceedings in which relevant material seen and relied on by the court is not disclosed to all parties to the proceedings. The Supreme Court so decided in Al-Rawi versus Security Service in 2012. The question on this appeal concerns the extent to which this rule applies to proceedings involving and following from the issue of a warrant for the search of premises and the seizure of relevant documents and information there. In this case, such a warrant was issued under Section 8 of the Police and Criminal Evidence Act by the St Albans Magistrates Court. The warrant was issued on the application of the respondent police force. The appellant was the occupier of the relevant premises. The order was made in his absence, that is, ex parte. It was executed. The appellant was given a redacted version of the respondent's application for the warrants, but was refused disclosure of the unredacted materials on public interest grounds. A challenge by the appellant to the lawfulness of the warrants led to a consent order in spring 2015 quashing them, but before consenting, the respondent police force made a protective application under Section 59 of the Criminal Justice and Police Act 2001 for continued retention of the seized materials. Section 59 allows continued retention of documents which would otherwise fall to be returned if, upon such return, it would immediately become appropriate to issue a fresh warrant for their seizure. The application under Section 59 was granted. The appellant sought a further judicial review of that decision. That was dismissed by the Divisional Court. The Divisional Court held that it was open to a magistrate issuing a search and seizure warrant and to a court deciding an application under Section 59 to act on material which had to be withheld from disclosure to the appellant on public interest grounds. The appeal raises 5 sub-issues. First, can a magistrate's court, when issuing a search and seizure warrant ex parte, rely on information which cannot in the public interest subsequently be disclosed to a person affected by the warrant? Secondly, can a Crown Court, on an application for continued retention under Section 59, rely on such information? Thirdly, can the High Court, on an application for judicial review of a magistrate's court's decision to issue such a warrant, or for judicial review of a Crown Court's decision to allow continued retention under Section 59, rely on such information? Fourthly, if the High Court cannot, what follows? Does it mean that the Magistrates' Court or the Crown Court order must automatically be set aside unless the material disclosed to the person affected is by itself sufficient to uphold it? Or does it, on the contrary, mean that the claim judicially to review any such order must automatically fail because the person affected cannot show that it was that the order was improperly made? Fifthly, do the principles concerning disclosure of an irreducible minimum apply to proceedings concerning search warrants, that is, an irreducible minimum of information? The Supreme Court, in a judgment written by Lord Mance, unanimously dismisses the appeal against the Divisional Court's decision. First, the appeal proceeds on the basis that there is no express parliamentary authorisation for the operation of a closed material procedure. However, on analysis, the statutory scheme of Sections 8 and 15 of the Police and Criminal Evidence Act permits a magistrate's court, on an ex parte application for a search and seizure warrant, to have regard to material which cannot on public interest grounds be disclosed to a person affected by the warrant or order, even where this material is decisive for the legitimacy of the warrant. The scheme is designed to be operated speedily and simply on the basis of information provided by a constable, satisfying a magistrate that there are reasonable grounds for believing the matters set out in Section 8, subsection 1 of the Police and Criminal Evidence Act. It contains nothing to restrict the information on which the constable should put before the magistrate or on which the magistrate may act. It would limit important sources of information and the efficacy of police investigations if a warrant could not be issued on the basis of all relevant available information. a statutory ex parte procedure of this nature is not within the general prohibition on closed procedures without express statutory authorization recognised in Al Rawi. Second, the Crown Court can, on an ex inter partes application under Section 59 of the Criminal Justice and Police Act, operate a closed material procedure. It is required to put itself in the shoes of a hypothetical magistrates court being asked immediately after the return of the property to issue a fresh warrant with a view to seizure of that property. Since the magistrates court would be entitled on such an application to have regard to information which cannot be disclosed for public interest reasons, it must follow that Parliament also contemplated that the Crown Court could operate a closed material procedure when acting as if it were a magistrates court, or as a magistrates court would do under Section 59. An analogy is provided by Bank Mellat and Her Majesty's Treasury, number 2 in 2014. There was there no express provision for the Supreme Court to operate a closed material procedure on appeal, but without such a power, an appeal against a wholly or partly closed judgment could not be effective. Thirdly, the High Court can conduct a closed material procedure on judicial review of a magistrates court order for a warrant under Section 8 of the Police and Criminal Evidence Act, or a magistrate's order for disclosure, or a Crown Court's order under Section 59 of the Criminal Justice and Police Act. Al Rawi is again not directed to this situation. An alternative analysis whereby, in the absence of a closed material procedure before the High Court, a claim for judicial review must either automatically succeed or automatically fail is unacceptable. Although judicial review and an appeal are not precisely equivalent, many of the considerations identified in Bank Mellat as favouring a closed material procedure in the context of an appeal also militate in favour of a similar result in the context of judicial review. It would be unjust and potentially absurd and potentially inconsistent with Section 31 of the Senior Courts Act 1981 if the High Court on judicial review had to decide an appeal on a different basis from that upon which the magistrates or Crown Court had correctly decided it below. Fourthly, and finally, as to the disclosure that should be made to a person affected, open justice should prevail to the maximum extent possible. However, it cannot be axiomatic that even the gist of the relevant information must be supplied to any person claiming to be affected and seeking to object to the warrant, search, or seizure. Each case must be considered in the light of the particular circumstances. The Supreme Court therefore answers the questions before it in this sense, and the appeal is dismissed accordingly.